Good afternoon and welcome to the Appellate Division First Department hearing a case out of turn from our normal calendar at 2 p.m. to accommodate the litigants. The case of Mezanev versus Tajibakova. Forgive me if I have destroyed the pronunciation of your names. Good afternoon to you both. Appellant, you have 7 minutes and 2 minutes for rebuttal, and respondent, you have 8 minutes. Mr. Mezanev, you may proceed.
Good afternoon, Justices. I'm profoundly grateful for allowing remote argument and for honoring the interest of the newborn. I have 4 points to make. Can you hear me all right?
Yes.
That's great. The first point is about the bad rule. The second is about the indigestion of salient facts. The third is about egregious fault and abuse of the system. The fourth is about the capricious and arbitrary nature of the orders, some of which shock the conscience and others were null and void even prior to reversal. Point number one, this is not a hard case. This is a miscarriage. And if you allow this to stand, you would be creating a new rule which says, to paraphrase Cardozo, the criminal not only goes free, but is showered with windfalls paid by an innocent parent whom the constable criminalizes after he runs out of money. This is bad law because it commits both false positive and false negative errors. It undermines the rule of law and the integrity of the system. Point number two, the lower court did not digest the salient facts. When you don't have a firm grip on the facts, you cannot possibly apply the law appropriately. But the problem is even more fundamental than that. When litigants show up, the lower court has an obligation to ask the most basic of questions. Why are these two people before me? Who and what is driving the conflict? Why did 1.5 million in fees go to attorneys? I paid 97% of that. The lower court confused spending with paying. Mr. Tajibakova took my equitable distribution check and paid for 3%. That is why I live with my mom in Plovdiv, Bulgaria, and Mr. Tajibakova lives on the Upper East Side of Manhattan in her own apartment, guaranteed and paid in part by me. Point number three, egregious fault and abuse of the system. Mr. Tajibakova was writing a costless insurance policy against deportation for herself using false child abuse allegations against me. On January 28, 2015, I asked her for divorce in the presence of both of our mothers. The very next day, she goes to Dr. Merkler to report child abuse. Our pediatrician is Dr. Merkler. To report child abuse retroactive to the week prior to Thanksgiving the year before. Page 1250 in the record captures Dr. Merkler's notes from that day. And he states, this is due to concerns about relationships with her husband, close quote. It is telling that the case was reported to ACS not by the pediatrician, but by the psychologist, Dr. Moulin, who was working next door. This is the penultimate line on page 1250, if you're following the record. Page 502 through 511 is an expert report testifying that Mr. Tajibakova suffers from PTSD, depression, and other personality disorders. Page 414 is Mr. Tajibakova's testimony as to why she reported child abuse the day after she was asked for divorce. And
so
there,
you're gonna run out of time, and I would like you to focus specifically on the issues raised in your appeal, specifically why we should grant the motion to vacate child support arrears and secondly, to reduce the child support amount that is due on a monthly basis, and the issue regarding the payment of attorney's fees. I think those are the central issues before us, and I'd like you to have enough time to address those issues. We are familiar with the facts and circumstances of this case, so you don't have to go through the entire record with us, but articulate your arguments with regard to those 4 issues, which is what we are ruling on.
I appreciate, Your Honor. I was told that I would be given 8 minutes and 3 minutes for rebuttal.
So a 1-minute difference doesn't change my statement to you. Okay.
I understand. I understand.
So,
well, the orders were so attenuated from their goals that they were capricious. And so I'll give you an example. So Referee Sugarman did not even mention that I was compelled to return to Bulgaria for economic reasons. As a result, the lower court imputed child support in a country I could not even visit, in a profession I was shut out of and had not worked for 4 years, and noticed me at an address I did not live and in a country I did not live. The basis for Referee Sugarman imputation was a one-time severance payment. So that was a basis for imputing income in perpetuity. It was a one-time severance payment. The referee penalized me, punished me for not waiving my caregiving rights in the employment matter, essentially saying, instead of encouraging a parent to exercise his role as a parent, she was punishing that parent in perpetuity. The Hague Convention...
Sir, asking a parent to pay their fair share of child support is not punishment. It is your duty as a parent. Each child is deserving of support of both of their parents. So I have to push back on your statement that you were being punished by being required to do what every single parent in this state is required to do, which is provide support for their child.
Your Honor, I don't want to interrupt you. At the same time, I would like to mention that guidelines and statutory and otherwise provide that child support be proportioned to the circumstances of the parent and not be unnecessarily burdensome to the point of suffocating that parent and to the point of foreclosing being able to maintain a household. And so I'm fully on board with this, and that's why I have paid more than $500,000 to Mr. Shibikova in child support, in maintenance, in fees, compared to the cost of raising a child, which is a fraction of that. So I'd like to think that, with due respect to you, that I've done, when I could provide money, I provided money. And privileging money over time or other ways a parent can contribute to their child is disadvantaging the child. And I could be of help to Janai in many other ways, and trying to.
So you are suggesting that you should be alleviated of your parental obligation to help support your child?
No, that's not what I'm suggesting. I'm asking that child support be proportioned to my circumstances. I was involved in an employment litigation. I was countersued by my employer and blacklisted from my prior profession. I did find a job in another profession, not a corporation. No, it's not a corporation. Corporations shy away from people who sued their employers of 12 years. But by a university. Unfortunately, on an adjunct salary, I couldn't pay for my own expenses, let alone everybody else's. I was maintaining 2 households in Manhattan and 3 litigation in 3 courts.
Okay, well, you'll have time on rebuttal, and the record should reflect that you have now received 10 minutes of argument time. All right, respondent, I know I'm saying your name wrong, and please forgive me. Miss Tashibakova, it is now your
Yes.
turn.
Hello. Hi. Thank you. I just wanted to, I'm going to be brief. And like I mentioned in my brief, the referee Sugarman's report from April 2020 regarding child support, equitable distribution, and counsel fees should be affirmed. We had an extensive 8-day financial trial in 2019. The referee Sugarman's report was affirmed by the Judge O'Neill Levy in 2021 entirely. This decision was decided by 2 judges. And I see there's no legal basis for him to appeal these decisions. The one judge, the special referee, she heard the case, and she prepared her recommendations. And another judge, she reviewed her recommendations and made her decision to affirm. Like I mentioned in my brief, this divorce has been taking way too long. It started when our child was only 8 months old, and now she's 8 years old. And the the appellant, he left the country on his own will without telling anybody, without advance notice. Judge Sugarman had no way of knowing that he's going to leave. That's why her decision does not say that. And the imputed income was based on his on how much money he could make. He has finished. He has the excellent academic credentials. He finished the 2 top business schools in the world: Harvard Business School and Wharton at UPenn. And he had 20 years of professional experience. So based on how much he was making and his experience, the income was imputed. And since he left in 2020, he hasn't provided any kind of support. No child support, no help with medical and dental expenses, no enrichment activities. So I'm sorry.
Okay.
Yet he produced and submitted a lot of motions to the court, which cost me, a lot of legal fees. I'm on my own. I work full time to support our child. I don't owe this apartment. It seems like when the appellant said, it sounded like I own this apartment. I don't owe this apartment. I rent this apartment, and all the expenses I'm covering myself. And his endless accusations and attacks for so many years. It's been way too long, and it cost me a lot of legal fees. I have paid all my money that I had to my attorneys, and now I still owe them a lot at this point. And since he left, he produced a lot of motions, a lot of appeals. Just recently, we have received the decision from the Judge O'Neill that I get the full physical and decision-making custody, and he already notified the court that he will be appealing that too. Since from 2015 to 2020, he had 5 different attorneys representing him. From 2019, he started liquidating his assets to Bulgaria. He was preparing to have another child, and he claims that he is a poor person, but he does not provide any financial statements from Bulgaria stating that he is a poor person. But he somehow affords to have a baby through a surrogate. In July 2022, he had a baby. So I don't get any support, 0 support from him, and all I get is all these harassments and attacks. Even this request for oral argument is another way for him to again attack me. If the judge's decision is not the same, it doesn't match what he wants to happen, then he blames them too for being biased, and unfair, and everything should be the way he thinks it is. And that's why it's been taking so long, and that's why it has cost so much. And our child is getting bigger, and her needs are getting bigger too. And I cannot afford to respond to all his accusations and motions and appeals. I don't have time for it, and I don't have energy for this. He's refusing to come back to see her. He's even refusing to meet her in Europe. It was suggested that we can go to Europe and he could see her there. He's even refusing to do that. So it seems like he's not going to stop appealing and filing motions and until he gets the results that he wants, but he's not going to get exactly what he wants. And I'm afraid that there will be endless legal proceedings over and over, but at the same time, our child is big now, and she wants to go to enrichment classes. She wants to go to summer camp, and I can't afford it financially. I don't know how I'll be able to cover my legal fees that I owe at the moment, but I'm just asking you to look into the Referee Sugarman's report and decisions and Judge O'Neill's decisions. Thank you.
Thank you.
I'm sorry.
No problem. All right,
I'm
Mr.
very sorry
Mezanov.
Thank you.
No problem whatsoever. Mr. Mezanov, you have 2 minutes since we went over on your last.
So there were many falsehoods there. My payment to the surrogate agency was in 2018 and 19. The pandemic interfered. That's why the child showed up 2 years later. So there were falsehoods. When you see a parent single-mindedly and as existentially invested in proving a co-parent an abuser and undermining his parenthood, I haven't seen Janai in 3 years. We haven't seen Janai in 3 years. All I wanted is to have and rear kids in New York State. If this is a crime, I'm guilty as charged. If it is a crime to assert Janai's right to have a father, and for me to be her father, I'm guilty as charged. If it is a crime to assert my right as a caregiver in the employment discrimination litigation, I'm guilty as charged. Compare my conduct to Mr. Shibikova's. In one court, she presents something. In another court, 177 yards to the west, she presents a completely different picture, always crying and appealing on emotional basis, not on fact basis. I am not masochistic, justices. I did not turn my life.
Mr. Mezanov, the decisions of the court below were not based on emotion. Okay? You are being disrespectful to the court. Those decisions were based on facts and law as presented to both the special referee and as accepted by the court. I will hear your argument, but you're going to stop disparaging the system. You may continue.
Thank you, Your Honor. I'm trying to be a parent the way I can. And
part of that is paying child support, sir. Part of that is paying child support. Do you have any other arguments?
I made another offer. It was not even responded to, and so I don't mind being settling on reasonable terms, but Mr. Shibikova demands something that I can no longer provide in the amount that she desires, and it is. I'm not trying to avoid my obligations. To the contrary. I'm trying to fulfill them the way I can and offer to help, not just with a parent cannot be replaced with a child support check, nor with an attorney, nor with strangers. And having fathers present in their children's lives is a value that is beyond the money. And the social science is unequivocal about this.
Okay. Thank you so much. This concludes the argument for this afternoon. You will receive the court's decision in due course. Have a good day, all. This ends the morning session.
Thank you. Thank you.
Thank you.
Thank you.